appeals on the matter of JP Morgan International and WeRealize.com Limited.
Good morning, Chancellor. Good morning, my lords. If I might begin, my lords, by referring to the reality principle, which my Lord Justice Lewison very helpfully drew to the attention of the parties, if I may say so, yesterday. And having had the benefit of looking at it overnight, if I might hand up to the court copies of a decision which will be familiar to my Lord Justice Lewison, which is the Secretary of State for Transport versus Curzon Park Limited.
Yeah.
Now, my lords, the facts are somewhat complicated, so I enter into them with some trepidation. But let me see if I can provide a fair summary.
And you know that the appeal from this decision was allowed in part?
I do, my lord. What we say is that the appeal doesn't affect my lord's analysis of the reality principle.
Well, would it be sensible if we read the head note? I mean, I haven't come across the case before. Perhaps if we read the head note to ourselves.
Indeed, my lord, that may, and it may well be that the head note writers can provide a better summary than
Well,
than
I'm
I've
not
attempted to
suggesting
do.
they do or don't, but sometimes it helps.
Yes, thank you, my lord.
Yeah.
So, my lords, a case concerning the compulsory purchase of land. Secretary of State for Transport acquired 4 contiguous sites for construction of a new rail terminus in Birmingham for the HS2 high-speed railway. When land is compulsorily purchased, compensation must be assessed on the basis of a hypothetical sale in the open market. Hence, the direct relevance to this case. Landowner is entitled to apply for a local planning to the local planning authority for what is called a certificate of appropriate alternative development, known as a CAD. The function of a CAD is to identify every description of development for which planning permission could reasonably have been expected to be granted if the land had not been acquired compulsorily. And importantly, where such a certificate is granted, it is to be assumed, for the purposes of assessing compensation, that planning permission for that development has been granted. the relevant statute, the Land Compensation Act 1961, requires, amongst other things, the assumption that the scheme of development underlying the compulsory acquisition has been cancelled at the launch date. This is known as the cancellation assumption. So in this case, the assumption being that one assumes that the HS2 project has been cancelled. In that case, the landowners argued that this also required a further assumption that CAD applications had not been made on the neighbouring sites. The Court of Appeal held that this was correct because it was the inevitable consequence of the cancellation assumption that no CAD applications could have been made. This was because a precondition for making a CAD application is that there is a proposal for the compulsory acquisition of land. If it is assumed that the relevant development has been cancelled, if it is assumed that HS2 has been cancelled, there would be no proposal for compulsory acquisition in the first place. So it is looking at how the relevant assumptions work in the context of an open market sale.
Mm-hmm.
If I might ask the court to look at paragraph 40 in the judgment of my Lord, Lord Justice Lewison, in which my Lord summarises in paragraph 40 by reference to a dictum of Lord Newburger in a case called Spire Rose, what the reality principle is. And then over the page, on page 42, my Lord refers to a previous judgment that he gave in a case called Harbringer Capital Partners versus Caldwell, and noting that it was a dissenting judgment, although Lord Justices Mummery and Beatson, who are in the majority, did not disagree with his statement of principle.
Should we read that through to ourselves?
Yes, my Lord, if you may read paragraph 22, please. What the paragraph 22 as quoted in paragraph 42. So, my lords, we put particular emphasis on 23 Roman 2 here. Giving effect to the hypothesis may require a legal impediment to the implementation of the hypothesis to be ignored or treated as overridden, but only to the extent necessary to enable the hypothesis to be effective. See IRC versus Crossman. In this case, the hypothesis is that the sale is an open market sale. It is a sale to a willing buyer that is not JP Morgan. There is a legal impediment to the implementation of that hypothesis, which is Regulation K, to the extent that Regulation K applies to JP Morgan by reason of its shareholding in Viva. That legal impediment is to be treated as overridden in order to prepare an open market valuation. We also put particular emphasis on the next subparagraph, Roman 3. The world of make-believe should be kept as near as possible to reality, the dictum of Lord Justice Lawton in a case called Troquet Property versus Greater London Council. This is what is sought to be achieved in our submission by the detailed data that is required under paragraph 3.7b, Roman 6, it is so that the open market valuation is not one in the world of make-believe, it is one which is grounded in reality. In this regard, we refer to what the learned judge held below in paragraph 102 of her judgment. Page 207 in the core bundle, paragraph 102. The learned judge addressed the submission made by JP Morgan. As to the submission that the hypothetical projections prepared by Viva would include revenues for untried, untested and unexplored activities, it is implicit in future projections that they may extend to new, i.e. untried and untested activities. But paragraph 3.7b Roman 6e provides for detailed revenue projections by revenue type and country and the key assumptions supporting the projected revenue details. And as referred to above, subparagraph 3.7b Roman 2 requires the valuation to be on the basis of the current and reasonably expected operational capabilities and with a qualitative summary of the group's current capabilities pursuant to 3.7b Roman 6g. The projections will therefore be based on the additional supporting information required to be provided by paragraph 3.7, which the valuations experts will then be able to assess as required by paragraph 3.6a. So we say, rather serendipitously, actually reflecting one of the aspects of the reality principle.
She misquoted paragraph 3.7b2, didn't she?
Quotation is incomplete.
Sorry,
It's
that-
incomplete.
Goes on to say while under the ownership of
Yes,
two shareholders.
yes, yes, yes.
we had that exchange yesterday.
We had that exchange yesterday. What we say, my lord, in relation to that is an aspect of the case being grounded in reality. That the draftspeople have said, this is as far as we're prepared to let you go in order to identify, or rather, this is key information that has to be provided, which is what is the current and reasonably expected operational capability under the joint ownership of WRL and JPM. So they're saying that is something which is, in our submission, something which can be tolerably identified as being reliable and realistic. So that's information which you have to provide. Not limited to providing that for the purposes of the valuation exercise, but that is minimum information which has to be provided. We say that the relevant identification of what the scope of the exercise is comes from 3.7a, C and D for the reasons the judge gave. And I apologise for jumping back to the decision in Curzon Park. There are two other aspects which we do place emphasis on. In Roman 4, we also underline or underscore that where the hypothesis inevitably entails a particular consequence, the valuer must take that consequence into account, citing a case called East End Dwellings Company Limited of Finsbury Borough Council. The open market valuation in this case entails the consequence that Regulation K does not apply. In the Curzon Park case, in order to make an open market valuation, the cancellation assumption had to be made, and that assumption entailed a consequence. The consequence was that it had to be assumed also that no other CAD application had been made. In this case, it is more straightforward. The open market valuation requires a consequence. The consequence is that Regulation K cannot be deemed to apply.
Why couldn't that just be done through clause 3.8?
Yes, my lord. We have several points to make in response to this. The first is, with the greatest respect, is not a relevant question. It's not a relevant question in our submission, because the relevant question here is, what does an open market valuation of a sale between a willing buyer and a willing seller require? That's the question which is posed by 3.7a. What is the valuation basis? The answer to that question is that the characteristics of WRL and JP Morgan should not be taken into account, and it therefore follows that Regulation K should be disregarded. So with respect, we say it is no answer to that question, what is the correct valuation basis, to say, well, Regulation K can be taken into account under a different provision, under paragraph 3.8. Because the primary question is, what is the basis upon which this valuation exercise is going to be undertaken?
I don't think the argument is that Regulation K can be taken into account under paragraph 3.8. I think the argument is that the value of Viva, untrammelled by Regulation K, can be taken into account under 3.8.
My lord, I'm grateful. I apologise. That's my misspeaking. That's quite right. So my lord, Lord Justice Snowden's question, as I understand it, is why can the non-regulation K world, if I can put it that way, to use the terminology which is used in some of the reality principle cases, why could the non-regulation K world not be taken into account under paragraph 3.8? And my first answer is not relevant, because one has to identify what the valuation basis is. My second answer is this isn't a panacea anyway. And we say that because of what the valuation experts could not do under paragraph 3.8 is take into account financial projections prepared by Viva concerning a non-regulation K world. You could not have, under this agreement, a parallel regime whereby under 3.7a you looked at a regulation K world, projections for a regulation K world, and under 3.8 you looked at financial projections in respect of the non-regulation K world. Why not? Well, firstly, because that would be to undermine what 3.7b Roman 6 provides, which requires projections to be approved under the regime, has to be prepared by Viva, approved by both shareholders. Secondly, that was indeed a finding which was made by the learned judge below on JP Morgan's own case. They sought this conclusion, and understandably, having obtained that ruling, they don't appeal against it in this court. So the basis upon which we proceed, and we accept that that ruling is correct, but the basis upon which we proceed is that financial projections prepared by Viva cannot be taken into account under paragraph 3.8. That is in the judgment.
How does that follow? I thought the judge was addressing financial projections under 3.76, not 3.8.
So the argument, my lord, was that it arose as a fallback case to my client's primary case. My client's primary case is under 3.7b Roman 6. It is a non-regulation K world.
Yes.
But if we're wrong about that, is it the case that what we could do is we could take the financial projections which are prepared by Viva concerning a non-regulation K world, or more particularly, even if it was the correct construction of Roman 6 was it's a non-regulation K world, but JP Morgan were entitled to reject the projections because if on its face they had an untrammelled right to reject the projections. The judge found in our favour there was an implied term to prevent them doing so. In that circumstance, could we take those projections and say to the valuation experts, you must consider them under paragraph 3.8 anyway? And the judge held no, because there is an approval regime in 3b Roman 6. And that would be circumvented if what you could do is just provide the projections anyway to the financial experts, the valuation experts rather, under 3.8. And that's what the judge held in paragraph 31, in paragraphs 108 and 109 in the judgment. It might be helpful to look first at how the issue was framed. It was one of the issues for trial. Paragraph 31 of the judgment on page 190 sets out what issue 3 of the trial list of issues was.
Sorry, I lost the reference.
So it's my fault, my lord. It's page 190.
90.
190.
Sorry, I thought 119.
Sorry, it's my lord. I have a bit of a cold, but I'm not inviting sympathy. But it's my apologies. It's a preface to my apology. Paragraph 31 sets out the trial list of issues, and the last issue was 3C. Are the valuation experts permitted or required to take into account any financial projections prepared by Viva for the purposes of 3.7b6 if they've not been approved by JPM? And the judge addressed this, or her conclusion on this appears at page 208, paragraphs 108 and 109. Now, we say the judge's conclusion is eminently correct, and we haven't challenged it on appeal.
Well, hang on. The list of issues only was saying, look at 3.7b6. If they're not approved, if whatever you put forward are not approved, can they be taken into account? Oh, you mean hidden in issue 3C are the words under clause 3.8?
Yes. So the argument was that they could be introduced under paragraph 3.8. That's what we said as our fallback case, and the judge said no, because that would simply be sidestepping the approval regime under 3.7b6.
Is there any more reasoning apart from that half sentence in paragraph 108?
My lord, that's the reasoning on this point in the judgment. We say it's correct, and we say that's sufficient, but that's the reasoning on that point.
Why is there a contradiction?
The contradiction, my lord, is because the 3.7b Roman 6 requires the approval of both shareholders.
But assume against yourself that you're wrong on 3.76.
Yes.
But what is required is to do with Viva as it is at the date of this hypothetical sale. Why does it contradict that to say, well, under 3.8 we can put forward material to show what Viva would be like after the hypothetical sale if the hypothetical buyer were a non-edge company? Why is that contradictory?
We say it's contradictory.
Complementary, isn't it?
We say, my lord, it is contradictory because the way that the valuation mechanism works is that one has a set of financial projections which are the base material for the valuation experts to work from.
Well,
And that...
Let me just put to you a completely different example. Let it be supposed that you are valuing a parcel of land.
Yes.
And one party says, well, if we can get planning permission for development, this will be worth an awful lot of money. We're going to value the land, have to value the land as it is, but then we can say, if we got planning permission, it would be worth 10 times as much. And then the valuation experts would have to decide, well, what's the prospect of getting that? That's not contradictory, that's looking at all sides of the question.
We make 2 points, if you may, in response to that. The first is we respectfully endorse the proposition that the valuation expert should be looking at all sides of the question, and that's actually part of the learned judge's reasoning below in relation to the commercial common sense of taking into account the non-regulation K-world. But with respect, we would say that my Lord's example doesn't capture this case, because the key aspect, or a key aspect of Roman 6 here, is that the projections have to be approved by both the shareholders. To be prepared by the company, approved by the board, approved by the shareholders. And that is because, we say, the experts are not sitting as arbitrators. That's what clause 3.5 provides. So the experts are not here to determine challenges between the parties in relation to the integrity of the projections. They're not supposed to receive competing submissions and then reach a ruling as to whether the projections are right or wrong. What they're supposed to do is say, well, this is the material which the company has agreed are projections as to its future financial performance. What does that mean for valuation? What discount rate should we apply? Do we accept what the company has said? And not have a debate between the valuation experts across between themselves and the parties in relation to what the projections, whether the projections are accurate or not. And that is also consistent with having what is a tight timetable for the preparation of the valuation opinion. They've got 15 days from when they get the material in order to prepare their opinion. And also it reflects, and if I may adopt my Lord Justice Lewison's observation yesterday, it reflects the fact that they're not being provided with a report. So the valuation experts are not providing a report to the parties. So this isn't a case in which the valuation experts take the data, they sift through it, they decide which bits they rely upon and which bits they don't, and then they provide a report to the parties, and the parties can then go and challenge that by way of arbitration or a challenge in this court. What this contract provides is, that is the data, the experts provide their opinion, they do it in a very short period of time, and it's only challengeable on ground of manifest error or fraud. And so we say that is the aspect of the mechanism which would be undermined if it were the case that a whole parallel set of projections could be provided by either or both parties. And it's almost inevitable that they would do so if they disagreed with the projections under Roman 6. So, my Lord, that's my response in relation to the paragraph 3.8 question, and thank you for giving me the opportunity to respond to it, because it was a point which my Lord raised yesterday, and which I'm grateful for the opportunity to develop my answer. The final point that we rely upon from the Curzon Park decision, and my apologies for hopping back to it again, is paragraph 43 of my Lord Justice Lewison's judgment. In paragraph 43, my Lord says, in my judgment, therefore, the starting point is the real world, modified either by an express statutory assumption or by what is necessarily inherent in the concept of an open market valuation. If there is ambiguity in an assumption that the statute requires to be made, then the principle of equivalence may assist in resolving the ambiguity, but that is not an overriding, independent and freestanding principle. What is of particular relevance here is the first sentence. We say, in this case, that there is likewise an assumption that must be made, albeit as an assumption that must be made as a matter of contract. There is an express assumption that JP Morgan is not the buyer, and there is an express assumption that it is an open market and arm's length sale. We say also that it is inherent in the concept of an open market sale that one does not value the company according to the characteristics of a particular buyer. So the first point we make in light of this authority, in light of the reality principle, is that the construction that the judge adopted below, we say, is entirely consistent with and gives effect to that principle. The judge reached that conclusion as a matter of construction and common sense, rather than by reference to these authorities, but it is entirely consistent, we say, with that principle. We say that the reality principle is very useful. It illustrates and informs how Schedule 1 is to be properly construed. We make a second point in relation to the reality principle, which is slightly more nuanced. In this case, the reality is a sale to either JP Morgan or WRL. So this is not the Curzon Park case, where the sale of the land is to one buyer, the Secretary of State for Transport, who is acquiring the land compulsorily, come what may. And the question is, what is the open market value? Here, the sale could be to one of two buyers, and the question is, what is the open market value? Now, if I were wrong in my first submission as to how the reality principle applies, and how the reality principle is consistent with what the learned judge held below, we would say that the reality principle could not provide much assistance in this case. And that is because there are two realities. It's not a reality and alternative reality. There's just two realities. There's two different propositions. Either could be the purchaser because they both have call options exercisable under different circumstances. How would one determine what departure from reality is acceptable when one doesn't know what the ultimate reality will be? When one doesn't know whether the purchaser will be WRL, not bound by Regulation K, or whether the purchaser will be JP Morgan, bound by Regulation K.
So your essential point here is that the basis of valuation must be even-handed as between the two different options.
Yes. Yes, my Lord. And that, we say, is inherent in the concept of an open market valuation. Now, my Lord, if I may, or my Lords, if I may now resume where I left off yesterday, which is I was about to embark upon business common sense.
Just before we get there, can I ask you one other question about
Yes,
3.7b6?
Yes.
The judge has held that JPM is not entitled to refuse to approve these various data on the ground of anything to do with Regulation K.
Yes.
Suppose that notwithstanding that, the parties don't agree the projections for other reasons, completely different reasons.
Yeah.
Who, if anybody, deals with that disagreement? Or does it simply mean that you can't put financial data of this nature before the experts because they haven't been agreed?
Well, my Lord, in that circumstance, the question is, what are the obligations of the parties in relation to approval? And what the learned judge held below was that the parties must act reasonably in relation to approval. And the judge below said that she was not going to go further than that. I think my clients invited to go slightly further.
I thought you kept telling us that JPM had an untrammelled right to refuse to approve.
No, my Lord. That's sorry, my Lord. If that was their case below. Our case below was that they had to act reasonably in approving the projections.
Sorry, that's just not right. Our case was, we accepted, it's paragraph 106. 107, you can see, we accepted. The difference is between the business plan and the projections. The projections, we accepted an obligation to act reasonably. The untrammeled right my learned friend referred to yesterday, as I understood it, was to the business plan.
Yes. Thank you.
Yes. Well, all right, let me put the question slightly differently. Suppose for perfectly reasonable reasons, JPM refused to agree the projections. Who then resolves that dispute? If anybody does, or does it simply mean that projections cannot be placed before the expert?
Well, my lords, the first question would be, are the parties complying with their obligations to act reasonably?
Yeah, well, I suppose they are. It
Yes.
just happens to be a perfectly good faith disagreement about what exchange rates are going to do, or some other matter which impinges on the projections.
Well, my lord, then the question would arise whether a term has to be implied to deal with that particular circumstance, which would require, for example, if there were two good faith legitimate objections, whether the projections were put to the experts on the footing that the differences between the two were identified and it became a matter for the experts to determine. One wouldn't assume that the contractual mechanism is wrecked and that the call options can't be exercised.
No, it might be that if there is a good faith reasonable disagreement, that paragraph 3.8 would come into play.
Well,
Yes, but look,
yeah.
we simply disagree about interest rates, or we disagree about the DCF that should be applied, or whatever. And so we can't give you an agreed set of data under 3.7. What we can do is we'll tell you under 3.8, this is what we are saying.
well, we would say that 3.8 is not the route out, because it does sidestep then the approval requirement, and that what one would envisage would instead be an implied term, which would say if and in the event that there was a good faith disagreement in relation to an aspect of the projections or aspects of the projections, such disagreement should be identified and provided to the experts with the balance of the data under 3.7 Roman 6. Now, the learned judge declined to go further than that in paragraph 107, which I'm grateful to my learned friend for reminding me of, holding that it seems to me that JPM has accepted in its submissions that it is under a duty to act reasonably in approving any financial projections pursuant to paragraph 3.7b Roman 6. But as to the content of that duty to act reasonably, absent a particular and present dispute, a declaration would serve no useful purpose, and I decline to make a declaration as sought. This conclusion, however, in no way detracts from or affects the conclusions above in relation to issue 3A.
So we've got two implied terms here. We've got the courts taking the account of regulation K in deciding whether or not to approve. That's implied term number one.
Yes.
And we've got a second implied term. If there is reasonable disagreement, then I haven't quite got what your implied term is in that event.
Now this of course is not an issue which was before the court below.
We've got to try and understand 3.76.
Yes. We would suggest that the implied term in that circumstance would be that in the event of good faith disagreement between the parties in relation to the approval of the projections, the differences between the parties in relation to those projections should be provided to the experts together with the projections insofar as agreed under paragraph 3.7b Roman 6.
How does that work? They're going to be approved. Under 3.76, they're going to be agreed between the shareholders. And what we're exploring with you is the extent to which 3.8 can be used to pick up a situation where there is, as my lord says, a perfectly reasonable disagreement between the parties about the accuracy of the projections, where at least on the wording of 3.8, it seems to me that the valuation expert who thinks that they are accurate does reasonably believe that they should be taken into account. Otherwise they just sort of fall into a black hole, don't they? If they're not agreed.
My lord, may I turn my back?
Of course you may.
Well, my lords, there are two different ways in which it could be dealt with. Either one deals with it at the approval stage, or the parties approve the projections and then they they make submissions afterwards to the valuation experts in relation to whether
The hypothesis is that the hypothesis is that parties have disagreed, but neither of them is being unreasonable.
yes.
And one's asking the question, how does one resolve that problem? Given the fact that under this contract, everything has to be done the day before yesterday.
Yes. Well, the material has to be provided ultimately to the valuation experts if there's a good faith disagreement. Then it becomes a question as whether the formally correct route to do that is 3.8 or 3.7b Roman 6. And we say it would be Roman 6 because if otherwise you've left the door ajar in 3.8 to just sidestep the approval requirement. So I mean, one could also envisage the implied term say then it had to be done under 3.
And then you've got financial projections prepared by the company, which aren't approved by the shareholders.
Well, yes, but that's what this implied term would have to deal with. So there's no express
Well,
mechanism.
the other way of looking at it, so you don't need the implied term at all, because you can use 3.8.
And we would say that wouldn't be the correct route because that would sidestep the approval requirement. Yeah.
Can I put a follow-up?
Yeah.
I mean, this debate illustrates something which we all know, which is this contract has to be operated with fairly short timescales. You would want, wouldn't you, to have a contract where as much as possible was agreed under 3.7 Roman 6 in any event. And given that a lot of the requirements under 3.7b Roman 6 are very detailed, such as I'm just looking at E, for example, detailed revenue projections by country and by segment, you know, through revenue categories, key assumptions supporting the data and everything like that. Now, if you're actually doing the business, those you would have thought would be relatively objectively ascertainable and capable of relatively easy agreement by people acting reasonably.
Yes.
If you're not doing the business at all of that type, and it's all in the future, there's a much greater likelihood that there will be a failure to agree because people will reasonably disagree. So why do you try and force to make this workable the future projections of something that the company isn't doing into, you try and shoehorn it into a clause which requires agreement rather than allowing it to be dealt with under 3.8 where agreement is not needed?
Because one starts from the valuation basis.
No, I mean, this is neutral. I'm assuming that you're right, that that all this is geared up to an open market valuation where in a world that Regulation K doesn't apply. But it's still a question of the mechanics as to how you get there. And what I'm saying, what I'm putting to you, is that you would use 3.7b Roman 6 in a way that maximised the possibility of agreement, which is what it requires, and minimise the possibility of disagreement. And you would put into the bucket marked not requiring agreement those more controversial potential, or at least speculative, projections that people might reasonably disagree on, but in which case they can bring it into account under 3.8. Why isn't that the way this is supposed to work? On the assumption you're right, on the core thing you're trying to achieve, which is an open market valuation where Regulation K doesn't apply.
Because we say that the whole of the SHA proceeds on the basis that the parties are supposed to be agreeing things in good faith in order to make the agreement work, such as the business plan. And in this case, the timetable for agreeing things occurs on fixed dates, which are some time in advance and in the future. So there's a valuation period every 6 months.
Yeah,
So and the raw data for that is going from the first valuation exercise, the first option exercise period, is they're going to be progressively updated every 6 months. So we don't accept as a starting point that it's not possible for the parties to address the relevant projections in time and consider them.
I didn't say it wasn't. I'm just saying that reasonable people have a greater tendency or possibility of disagreeing on something which is entirely speculative and in the future. They have less reason to disagree reasonably on things that are actually happening.
Yes.
And when you get down to that level of detail that is required here, why doesn't the drafter assume that the parties are likely to be able reasonably to agree something which is actually happening, a projection based on something that's actually happening, rather than something which is completely speculative?
Because we say that one has to stand back rather than just focus upon what may or may not be the case as a matter of commercial convenience or commercial ease of agreement, and look at what the contractual principle is here. And the contractual principle is that one must give effect to clear terms in the contract, and one must read them as a coherent whole. We would say it doesn't give effect to what is the valuation basis 3.7A, B, and 3.7A, C and D, as the judge found, to then say that the projections to be produced for the purposes of that valuation process could proceed on a different footing. We say you have to read it as a whole, and my lords, I'll come to this in a moment if I may. We say, and we're completely clear about this, we say there is no room here for an argument in relation to commercial common sense. And with respect to my Lord Justice Snowden, the points that you're putting to me are points which are commercial common sense points. My Lord is saying, would this be an impractical way of going about conducting the valuation exercise? And we say, with respect, this is a very clear contract. That's what the judge held repeatedly. He said it's clear, it's very clear, the language is clear, and in those circumstances, we say that you don't end up in the territory of saying, well, could the parties have agreed something which was commercially more sensible? It looks like it could be an impudent contract.
I mean, one point, and then I will leave this. I don't think I'm just doing it on the basis of commercial common sense. I'm looking at the requirement for approval, i.e. agreement in 3.7b6. And I'm asking what is more likely to result in approval as required by 3.7b Roman 6, and that which would not. So it's not, I'm not just using business common sense divorced from the words of the contract. I'm simply asking which alternative gives the greater effect, or is more likely to allow for the approval required by 3.7b6.
My Lord, I'm not suggesting that it's my Lord's making a freestanding appeal to commercial common sense, but what I am saying is that has to be the basis for the argument, has to be the coherent basis for the argument, has to be that it's commercial common sense. And if I may adopt what my Lord said, well, not adopt, if I may repeat or paraphrase what my Lord said, which is that it is more likely that business people will disagree about future activities which they're not conducting, business activities they're not conducting, than those which they are. Now that is, we would say, a commercial common sense point, which is saying the likelihood is that in the world of business, people will be less likely to agree in relation to these matters because we expect that there could be a greater degree of variance than when they've actually got the financial data for the activities that they're currently conducting. And then the question has to be, is there scope for a commercial common sense argument? Because, at risk of stating the obvious, if the language is clear, if there is no competing construction put forward as well, then the position is that the parties have to live with the bargain that they've struck. If there's unambiguous language, the court must apply it. Here, there is an unambiguous language. There must be approval. And we say the parties have to live with that. If they've created something which is difficult to work in practice, then ultimately that's their problem, unless there is a ambiguity or there is some other rival construction based upon an ambiguity which allows that sort of point to be made. Otherwise, we're in a situation where an appeal court would be, in the greatest respect, rewriting the bargain that the parties have struck. So if I may deal with what I was going to say about commercial common sense, and hopefully that will make good some of the submissions that I've just made. If I might ask the court to turn up the Palladian decision, which is in the authorities bundle at tab 22. Tab 22, page 542. And if I could ask my lords to turn, it's in the lead judgment of Lord Justice Popplewell. Of course, my Lord Justice Lewison will be familiar with this in particular.
So which paragraph?
We rely first of all on paragraph 58, but we're actually relying on the part of the paragraph which is the quotation from Lord Newburger in Arnold and Britton, which is at the top of page 557. And if I might ask my lords, in fact, to read paragraphs 59 through to 61. So, applied to this case, we say this is a contract which has been negotiated and prepared with the assistance of skilled lawyers, and where the provision in question is an important one. It's about the most important provisions that one could imagine, the provisions for the call options in this contract. It is one on which the court can readily assume that the lawyers and their clients kind of focus their attention and have taken care to ensure that they accurately express their bargain. The court, we say, in this case, as in Palladian, should not readily conclude that sophisticated parties involved in agreeing to it, with their understanding of the business and their benefit of advice from lawyers on both sides, would have regarded the economic and commercial consequences as anything other than flows from the words. So here, in my Lord Justice Snowden's example, the word approval. Of course, it would have been obvious to the parties that they could have provided a mechanism, a default mechanism, to deal with what would happen in the absence of approval. And they could have avoided having a mechanism which required them both to approve, but that's what they decided to do. And one can see that because if one can have one's own commercial interest in saying, well, it's almost, a case of mutually assured destruction, that the parties are going to have to agree. And we don't want to be in a position where we give the right, say, to WRL to agree, or WRL to allow JP Morgan to have a veto for its part. And we also rely upon paragraph 61. There are a number of different outcomes which the parties might hypothetically have wanted to achieve, and that also applies in respect of the approval mechanism. But ultimately, we say the language is unambiguous, and that follows from 3.7a, C and D. So we say, headline point is there's just no room, no scope in this case for arguments which come from the place of commercial common sense. Now, if I'm wrong on that, if there is a place for commercial common sense in this contract, then we say that a construction which involves regulation K not being taken into account as the valuation basis or as the projections makes abundant commercial common sense. And we say it for several reasons. First of all, at risk of repeating myself, WRL and JP Morgan each have a respective call option that they may each exercise under different conditions. Accordingly, either WRL or JP Morgan may be the ultimate purchaser, and that's how Schedule 1 has to be interpreted. It would make no sense, whether common or commercial, to value Viva on the basis that JP Morgan would be the purchaser. Yet that would be the consequence of taking Regulation K into account in the valuation. That would be the consequence because of Regulation K can only apply to JP Morgan, not to WRL. Second, JP Morgan could procure that Regulation K ceases to apply to it now. It could also procure that Regulation K ceases to apply to it in the future. It could do so simply by dint of transferring ownership of Viva to a different JP Morgan entity that was not an Edge corporation. And JP Morgan accepted that below. They said that the commercial synergies for them of the deal would be lost, but they accepted that this whole obstacle, Regulation K, could be disposed of, but simply by dint of transferring it to, not even to a third party, to another a third party, but another third party that's owned by JP Morgan, a JP Morgan entity. Third point, JP Morgan could realise the full unrestricted open market value of Viva upon purchasing WRL's shares. It could do so by at least one of two means. It could simply buy the shares and sell them to a third party that's not an Edge corporation. A flip. It could simply flip their investment. They could do it on day one as soon as they acquire the shares. Alternatively, they could make an IPO of Viva or any part of JP Morgan shareholding in it. We say that it makes no sense, either commercially or as part of an open market valuation, to proceed on the basis that the shares should be valued on the footing that they have X value if the day after the sale they would have a completely different value in the open market.
That doesn't follow at all. The potentiality of realising the value is part of the open market value, whether Regulation K does or doesn't apply.
Yes.
It doesn't require you to disregard Regulation K. I mean, suppose that if one particular buyer could realise untapped value of an asset, the untapped value will be reflected in that buyer's bid, and if it's the highest bid, it will be the open market value.
Yes. And that, my lord, we accept. That's the proposition that the higher bidder is going to be the open market valuation.
Yes.
And so that
the market is made up of everybody who is capable of bidding, whether they're Regulation K companies, Edge companies, or not. And we go back to all the old cases about special purchases, so IRC 1911, somebody wants to value a field, and it's of particular value to the farmer next door. Will you take his bid into account, as being somebody for whom this property has special value? Same if you've got a valuing a lease, and if it's if the freeholder buys it, he's got an unrestricted freehold which he can then sell on the market. So that's inherent in the valuation process. You don't have to assume that what you're selling is not the lease, not the field.
Well, my lord, we would say that in this circumstance you do, because it is being argued by JP Morgan that the valuation basis should reflect Regulation K. And secondly, because the data which has been provided on JP Morgan's argument is data which only reflects Regulation K.
I don't think those are the same question, actually. I think the 2 points you've made there that you've attributed to JP Morgan, the latter is certainly correct. That certainly is their argument. I'm not sure the former is.
Well, my lord, if that's the case, then the projections don't match the valuation basis, and that's incoherent because that's not giving effect to the contract as a whole.
No, the projections are part of, undoubtedly part of, the valuation basis because they are what is going on and what is projected for the businesses which are currently being conducted. And it's not excluded that you can bring into the valuer's mind in determining the call option fair market value of the shares a possibility which is not currently being pursued but might in the future be if Regulation K doesn't apply. So you just get to where you want to be, where you say you have to be under 3.7A through a different route. But I don't think, and I will be corrected, but I didn't really hear Mr. Design arguing strongly that you, for example, would be prevented from saying under 3.8 to a valuer, look, the purchaser in the open market is somebody who might not be restricted by Regulation K, and please, will you take it into account?
We say,
I mean, if I'm wrong in that, then doubtless somebody's going to jump up and down and tell me I haven't been listening. But I'm getting a few nods on the other side, so I think that seems to be the right.
we say, my lord, that two things. Firstly, that the projections must reflect the valuation basis, because the mechanism here is that projections are prepared in order for the valuation to be conducted, and that it is completely wrong to say, well, this is the valuation basis, but we're going to provide projections on a different basis, on a Regulation K basis, and leave it to you to argue that these matters should be taken into account under paragraph 3.8.
Yeah, I think you made that point,
Yes.
Mr. Weeks.
Nothing.
Secondly, we say that one has to be practical about this, which is that there is a fundamental difference between the projections under Roman 6 and a 3.8 submission. Roman 6, the valuation experts have to take them into account. They're required to do so. It is their base material and it is very detailed. And the valuation experts can proceed on the basis that the parties have agreed them and approved them. And the boards approve them as well. 3.8 doesn't have any of those safeguards. It is a matter for discretion of the valuation experts, and the valuation experts will then simply say, well, no, we've got the data under Roman 6. We don't accept that these projections are helpful. We will rely upon the data under Roman 6. And at that point, the experts are proceeding on the basis of data which doesn't reflect the valuation basis. We would say that doesn't make any commercial sense at all. And in that regard...
Well, actually, but it does, because one valuer will say, I think you should be valuing this company on the basis of projections that it can do business in the US because that's what a buyer not bound by Regulation K will do. If the other one did say, actually, I'm only interested in a Regulation K world, and there's no assurance that would be the case, and arrived at a substantially different value, then you've got a dispute resolution mechanism built in to the clause.
In what respect?
You've got a third valuer, because there'll be
Yeah,
more than
third
50, there'll be more than 15% apart.
That doesn't assist, my lord, because the third value. First of all, it assumes that one of the valuation experts will accept that the non-regulation K projections are an assistance. And secondly, the third valuation expert is not an independent opinion which they provide, which provides the data. They're not a tiebreaker in that sense. It's an average of them and the next closest opinion.
Yeah, but they're still reaching the third valuation expert will still be reaching an opinion on the basis that one or other of the hypotheses was correct.
Well, but as I understand, my lord,
How it then pans out in terms of getting to an eventual figure is, as you rightly say, it's like a baseball arbitration, but the actual third valuation expert will arrive at his or her own figure.
But they're in the same. The experts are all independent. They're so the third valuation expert has no particular magic, and his or her opinion is then averaged.
And all my questions are put to you on the assumption you're right.
Yes.
That the overriding and guiding principle is that what you require is an open market value under 3.7a, with and because that's what it says.
Yes, and well, my lord, could I just refer to paragraph 85 of the judgment below, page 204, which we respectfully endorse. However, it seems to me to make commercial sense that the value of the business to the purchaser will include an assessment of its future value and its future prospects, and thus where the current business is operating under regulatory constraints as opposed to operational constraints, which apply as a direct result of the particular shareholder, but will be free of those regulatory constraints in the future, the value of the business should be determined by the valuer disregarding those regulatory constraints. Although the value to be placed on the future business is still a matter to be determined by the valuers in their professional judgment, and having regard to the information provided to it by Viva pursuant to subparagraph 6, including its operational capabilities. We respectfully endorse that, and that logic applies both to the projections as it does to the valuation basis. The two cannot be treated separately.
You presumably you'd say the operational capabilities that the judge refers to at the end of the paragraph are the operational capabilities in the hands of a third party not affected by regulation K.
Yes.
So how do you square that with 3.7b2?
Because in 3.7b 6g, one has to provide the current capabilities together with the projections. So what one is using is current capabilities as a tool to assist with the projections. What one's not doing is saying that the tail should wag the dog and that the projection should be allowed to determine the valuation basis. We say that the starting point here is the projections are ancillary to the valuation basis. They're projections produced for the purposes of conducting the valuation on that basis. That's why it provides in Roman B6 that they're projections to be prepared. They are to be prepared for that basis. And if fresh projections are to be prepared, the question then becomes, why would you prepare fresh projections which don't reflect the valuation basis? That would be illogical. That might be why JP Morgan argue that the valuation projections should be those contained in the business plan. But there's no textual basis for that argument at all. What is clear from 3.6 and 3.7 is we say the valuation basis is non-regulation K. Projections have to be prepared afresh for the purposes of that valuation. We say it would be illogical to prepare projections then which reflect a different valuation basis, a regulation K valuation basis. And what this comes down to is a couple of points which JP Morgan make, which they require for this argument. The first is their argument that financial projections should be treated as separate from the valuation basis. And we say that is an incorrect argument. We make these points in relation to 3.6 and 3.7. They have to be read as a coherent whole so that the paragraphs are consistent with each other. That is a basic rule of contractual construction. Valuation is a unitary process. Second, there is an obvious hierarchy, both as a matter of logic and as a matter of structure or form, in 3.6 and 3.7. Look at 3.6 and 3.7 on page 527. Paragraph 3.6 sets out the general approach to and method of valuation. It must be read together with paragraph 3.7, both being expressly concerned with the same subject matter, i.e. the determination of call option fair market value.
And 3.8.
Yes, my lord, yes. We say that the way this works is 3.6 sets out the general approach to a method of valuation. Paragraph 3.7 sets out the basis of the valuation, and paragraph 3.8 says additional matters may also be taken into account. And the key paragraph in all of this is 3.7a, because that sets out the valuation basis.
Can we just pause a minute at 3.6a?
Yes.
Do you say the historical performance of the group should be assessed as if in a non-regulation K world?
No. We accept that historic performance is what it is, just as the judge did below. It means actual performance. It wouldn't be historic performance to say that it has to be subject to a counterfactual assumption that regulation K didn't apply. But just as the judge did below, we say that there is no indication then in the balance of 3.6a as to what projected financial performance means. It doesn't say actual projected financial performance, previously projected financial performance as projected in the business plan is neutral. One has to look elsewhere.
Well, if it said actual projected financial performance, I doubt that the lawyers have paid any attention to it. Actual projected is a contradiction in terms.
Yes, my lord, that's probably my bad drafting rather than theirs. It would have to be projected financial performance that has been previously projected by the company as approved by the shareholders, for example, or previous projections of financial performance, or historic projections of financial performance.
It's projected financial performance of the group in its current operational state.
No, we don't say that. We don't accept with respect that those additional words are apparent from 3.6a. We say that it's just blank as to what the projected financial performance means, and then one has to look elsewhere, reading the contract together as a whole. And we say that 3.7b and to F are ancillary to or subject to 3.7a because 3.7b to F set out some particulars of the valuation process. They identify what should and should not be taken into account in order to give effect to that valuation basis. That's why the valuation basis is 3.7a. And what JP Morgan is seeking to do is take a sub-paragraph in 3.7, 3.7b Roman 6, and argue that that should either be independent of the valuation basis or determine the valuation basis. And as the judge held, 3.7b Roman 6 is only one part of the picture and cannot override the other provisions of paragraph 3.7. That is the import of paragraph 100 of her judgment. We say that paragraph 3.7b Roman 6 must be read consistently with the valuation basis, which is in 3.7a. We need to give effect to it as a coherent whole. The next step in JP Morgan's argument is to argue that 3.7b Roman 6 is referring to projections that were in the business plan or are based on the business plan. That's a necessary step in their argument. Their argument is that 3.7b Roman 6 reflects projections which are in the business plan or based on the business plan.
Isn't that sensible? Because the business plan is agreed and there's a requirement to agree these projections under 3.7b6.
Well, my immediate response to that is my previous answer, which is that absent some ambiguity, one doesn't start from the proposition that what is the more sensible approach. Would it be more sensible to provide that these should be the projections contained in the business plan?
Well, it's sensible in a drafting sense because it's requiring agreement of something derived from something which also requires to be agreed.
Well,
There's
my
a
lord,
sort of consistency of drafting.
but there is no ambiguity and there is no textual basis, we say, for that construction.
Why not?
Because
You ask yourself the question, what's the most obvious financial projection prepared by the company which has been approved by the board and the shareholders? The answer is the projections contained in the business plan.
well, we may
Albeit conceivably updated because the business plan might be slightly out of date. But they're financial projections prepared by the company and they've been approved.
Well, my lord, as the judge held below, which we respectfully endorse, the term business plan doesn't appear anywhere.
That's
in paragraph.
really, that's, we've got that point, but
Secondly,
Hang on, sorry, you say it doesn't appear anywhere. What do you mean it doesn't appear anywhere?
there's in other parts of the contract.
in 3.6 and 3.7,
True, but I mean,
it doesn't refer to business plan.
no, but the concept of a business plan is obviously within the contemplation of the draftsman of the court option because it's in the rest of the agreement.
And we say that's a point strongly in my client's favour, because it plainly was in the mind of the draftsman that there was the business plan, and rather than refer to the business plan in Roman 6, what we set out very detailed provisions concerning projections that had to be prepared.
But that's because the business plan isn't always the be all and end all for the purpose of at the point in time at which the option comes to be exercised, because it may be, as my lord has just pointed out, not quite up to date.
But in those circumstances, the draftspeople would have provided projections based on the business plan as brought up to date, as updated, rather than have the best part of, or more than a page of detailed provisions as to what has to be included. That's why we say there is no textual basis, and that's why we pray in aid cases such as Arnold and Britton, Palladian, Rainy Sky, for the proposition that unambiguous language should be given effect, and that in sophisticated commercial contracts, one doesn't expect the parties, if they've used a defined term and have a defined concept, then instead not to refer to it, set out detailed provisions which don't correspond to that concept, at least don't consistently correspond to that concept. It would be a completely different provision in Roman 6. As the learned judge held in paragraph 73 of her judgment, if the parties had intended to refer to the business plan here, doubtless they would have done so. And we say there simply is no mandate then for reading Roman 6 to mean the business plan. The absence of reference to a business plan in this context is consistent with the parties not intending to refer to it. Moreover, the clause refers to financial projections to be prepared by the company, approved by the board and shareholders and provided to the valuation expert. Financial projections that are already contained in the business plan are not projections which are to be prepared in the future. This is a point made by the learned judge in paragraph 73 of her judgment. We look at page 489 in the contract. So the same contract, of course, which was same draftspeople in the main contract as the schedule.
Sorry, can you give me the
So
reference?
page 4, so I apologise, my lord, page 489, paragraph 10 point, clause 10.5.
Yep.
This records, prior to the effective date, the company has adopted the existing business plan, the existing budget. The existing business plan and the existing annual budget shall continue to be applied by the company following the effective date. That is inconsistent with the notion that the financial projections are to be ones which are to be prepared if they were to be contained in the business plan.
So the idea is that there's a business plan which they're obliged to comply with and which continues to be applied by the company. But in a sort of parallel universe, the company has to engage in a completely new series of projections for the purposes of clause 3.7 of Schedule 1, even though it's already done the exercise in the business plan, country by country.
Well, the projections which are referred to in 3.7b Roman 6, first of all, they don't cohere exactly to the business
Well,
plan.
they don't cohere exactly. I follow that point. The micro-macro stuff doesn't seem to be in the business plan. But quite a lot of it is. Are you saying that they couldn't use the business plan, for example, as the basis for the projections?
No, not insofar as the business plan is prepared on the basis of Regulation K, because that would reflect an assumption which is not part of the valuation basis. That's the fundamental difference. So, of course, if it were the case that one was looking at the territory of Sweden, so there wasn't a Regulation K problem, then one might say, well, what did we say in the original business plan back in when it was agreed prior to closing, and say, how can that be updated to reflect what the current position is in Sweden or Norway? But what one would have to do is prepare financial projections that cover the territory of the United States. Otherwise, one would not be giving effect to the valuation basis. Now, my learned friend also referred in this context to a discounted cash flow analysis, and he said that this supported JP Morgan's construction. He referred to the discounted cash flow analysis in where it's referred to in B Roman 6. It's D. It's capital D. The unlevered discounted cash flow analysis. Now, it's a small point, but we don't understand why a discounted cash flow analysis tells one anything about the type of projections that have to be prepared, Regulation K or non-Regulation K. A discounted cash flow analysis helps to determine the value of an investment based on its future cash flows. The present value of expected future cash flows is calculated using a projected discount rate. If the future cash flow is projected, it can then be used in a DCF analysis. A typical disadvantage of a DCF's analysis is its reliance on estimations of future cash flows, which could prove to be inaccurate. That is true of a territory where a company is doing business just as much as a territory where a company is not doing business.
Actually, I'm not sure I agree with the words just as much as. If you're doing business and have been for 50 years, your likely projected future cash flow over the next 3 years is going to be more accurate than a country where you've never done business.
My lord, that I think I would have to accept that as a proposition, but it doesn't mean that an unlevered discount cash flow analysis cannot be done in respect of a territory where
That's not the point you made.
no. Well, my lord, I accept the proposition that it is perhaps less likely that a discounted cash flow analysis could be vulnerable to the objection that the projected cash flow is inaccurate.
Reasonable disagreement between people acting in good faith who are required to agree.
Well, my lord, I think that goes back to the debate that we were previously having. What I'm saying is that the fact that one refers to a discounted cash flow analysis doesn't tell one anything about the basis of on which the projection should be prepared. It's neutral. Because it's a valuation technique that requires reference to.
Yeah, but it's inherently, I think that I certainly accept the point you made that the discounted cash flow is inherently capable of reasonable disagreement, and the variables you put in and the yield and the discount rate, are matters of real judgment.
Yeah.
And are likely to lead to disagreements. The more so if it relates to somewhere where you've never done business rather than somewhere where you have done business. So if the clause requires you to agree, it's more likely to be capable of being performed in relation to places you are doing business rather than places you've never done business.
Well, I'm not going to disagree with the proposition that it's going to be more difficult to agree in relation to places where you've not done business. It's more scope for reasonable disagreement. But what we do say is that there's no basis for either using that to review or revise what the basis of valuation is, and there's also no basis for entering into that sort of debate which involves saying what is more likely to be generating disagreement.
Just to be clear, I'm not using it to revise the basis on which the valuation is to be done. I'm just using it to debate with you the materials to be provided under 3.7b6 as opposed to those which might be provided under 3.8.
Yes, and but my lord, I've made my points on that. I mean, the position is that the projections have to reflect the valuation basis, and secondly, if that was what the parties had intended, then one would expect the Messrs Freshfields or Sullivan and Cromwell would have said, well, perhaps rather than refer to DCF analysis, should we not just say that the projections should be the ones contained in the business plan that should be updated? Well, we got A to G here.
Yeah.
We also don't accept the assertion which was made by my learned friends that it is somehow untried, untested or unrealistic to include projections in relation to a territory in which one has not been previously doing business. On the contrary, these projections have to be grounded in the detailed data which is stipulated, and importantly, in the assumptions which are relied upon. So we see in subparagraph E, when one is projecting revenue, one has to identify the key assumptions supporting the projected revenue, including the assumed number of merchants, volume and headcount by country and by segment. The number of employees have to be identified. Likewise, in relation to expenses, headcount expenses, key assumptions supporting headcount expenses, including headcount detail broken out by function and corporate title. So the individuals who are going to account for the expenses have to be identified. Marketing expenses and the key assumptions used to derive marketing expenses. Other expense items, including infrastructure and occupancy, including but not limited to detailed projections of depreciation, amortization, interest expense, cash taxes, changes in net working capital, capital expenditures, none of which are, as far as I'm aware, in the business plan. So we say that the suggestion that this is commercially unrealistic is not reflected in Roman B6 at all. And in any event, this is an argument or an assertion which would prove too much, because of course we can see in the business plan itself that Viva was content to estimate and project what its business would be in territories where it was not doing any business at that time. Thirdly, if this were the case, JP Morgan could, and it believed the projections are wrong, JP Morgan could withhold its approval. That's the contractual safeguard it has under Roman B6. Fourthly, this complaint ignores the nature of the exercise. It is an exercise in expert determination of value by independent and professional valuation experts, involving commonly accepted valuation methodologies. JP Morgan asserts that the projections would be unrealistic. If so, the valuation experts would have to make that determination in light of all the data available to them, and they would doubtless reflect that in a discount rate or a rejection of what has been proposed by way of a projection. The final step in JP Morgan's argument is to say that Viva has no operational capabilities in the United States. And that is a point which my Lord Justice Snowden raised yesterday and today, which refers to 3.7b Roman 2. And what we say in response to that is it is wrong to assert that Viva has no operational capabilities in the US. True it is not undertaking activity in the US, but that doesn't mean it doesn't have the capability of doing so. And I referred yesterday to the MasterCard deal. That is an operational capability under the ownership of WRL and JP Morgan, which is relevant to conducting business in the United States. Ergo, we say, Roman B2, in any event, does not assist in determining either what the valuation basis should be or what information should be provided by way of projections. So if we take stock in relation to the valuation dispute, what we say is the judge was correct with respect for the reasons she gave. The language is very clear. The valuation basis is very clear. The valuation basis accords with commercial common sense. One has to read the clause together as a whole. It would be flouting that basic canon of contractual construction and also illogical to require that the projections do not match the valuation basis. It would make no commercial sense in circumstances where the main body of data being provided to the experts upon which they must rely would simply not reflect the reality of an open market valuation, because they will be provided with data which, on JP Morgan's argument, is only concerned with the Regulation K world. My lords, that's what I propose to say about ground one. Ground 2, as I understand it, is now said to be entirely contingent on ground 1. So I understood the argument might have been that that fresh financial projections could be refused by JP Morgan on the footing that they didn't reflect, on the footing that if the valuation basis were non-regulation K, nevertheless they could reject them on the basis that the projections were non-regulation K. In other words, that they would still retain a power of veto. But that argument, I don't believe, is pursued anymore. Well, that takes us to the third valuation expert issues. My lord, I'm just reminded before I proceed to those issues that I should also make, which I left out from the commercial common sense points, should make the point which I made by way of background yesterday, which is that the business plan doesn't reflect the current reality as accepted by JP Morgan. It doesn't reflect the position that they accept that activity can be conducted under Regulation K in the United States. And the parties have been discussing that. It doesn't reflect that position, and therefore it again would make no commercial sense to require the valuations, the projections provided by the valuations, to proceed on the footing of something which the business plan doesn't reflect anyway.
I think we've got that point.
Third valuation expert dispute, ground 3, concerns the appointment of the third valuation expert from the outset. The learned judge held that it is a condition precedent to the appointment of the third valuation expert that the determinations of call option fair market value are more than 15% apart. The learned judge was, with respect, quite correct to make that finding. The starting point is that, as the judge held, this is a construction issue that cannot be resolved by purely textual or purely literal construction. This is because neither construction advanced by JP Morgan nor that by WRL perfectly coheres to the text of paragraph 3.10. We could turn that up, please. That's at page 530. The ordinary meaning of the term, then the parties shall appoint, in subparagraph B, is that first valuations are made and then
It's predicated upon there being more than 15% apart.
Yes.
You need to have that first and then you appoint.
It's as simple as that. It's as simple as that. And
There's other language in the clause which is difficult to reconcile with that analysis, but I mean that's the argument.
yes, my lord.
And appoint means what it says.
Yes, and that's what we say. That's what we say. And in order to make the clause work, all one has to do is change the word's effective date, because that's a defined term. And one has to just change it, and you could come up with a variety of different things, but relevant date would work.
Just excise it.
Just excise it. Yeah.
Just-
Yes, it just decides it. Yes, well, indeed, indeed.
You've got the valuations, you know, you can work out
Within
whether they're
10
more than
business days of
15% apart.
valuation.
Yes.
So off you go.
Indeed, indeed.
You say, it's a matter of ordinary English grammar, if, then, is a condition, and what happens if the condition is fulfilled?
Indeed, indeed. And my Lord Justice Snowden.
And a point being used twice in the same clause means the same thing. It's not a point to a role as opposed to a point to a task.
Yes. Yes, and I felt, with respect, my Lord Justice Snowden asked yesterday, said that JP Morgan's construction simply doesn't reflect the conditionality in the clause, and it doesn't. And my learned friend, Mr. Handyside, I think, was constrained to accept that, was correct. So we say that the true it is that my Lord said one could simply delete the words effective date, but everybody understands what it means. It can simply be corrected by construction. It doesn't do violence to the clause. Not only does JP Morgan's construction involve using the word appoint in two different meanings and creating a new office of appointment? What it does is create a double appointment. It requires a third valuation expert to be appointed at the outset and then appointed to a role. And it elevates what is obviously contingent or conditional obligations in Roman 1 and Roman 2 into freestanding obligations.
We can't make any sense of appointments in the closing words of the clause unless it means something different from elsewhere, because obviously within 15 days of its appointment, if it's been appointed on the effective date or within 10 days of the effective date a year ago, it's not being asked to do the exercise within 15 days of appointment. So on that hypothesis, appointment means something else.
Indeed, indeed.
To say the least of it, most unlikely.
Indeed, and my lord, two further points to make before we might move on from this, is that it would require extra words to be read into the clause. I don't know what JP Morgan is saying the words are, but there would have to be new sentences read in to deal with the appointment to a new role. And then the learned judge held as well that it is not consistent with the contract as a whole. And that's if we might remind ourselves what paragraph 3.2 provides, which is on page 526.
Yeah.
This provides for the appointment of each side's respective valuation expert at the outset. It then provides, down the page, each shareholder shall maintain the appointment of any valuation expert appointed by it until, as the earlier of, the valuation expert informing that shareholder that it is unable to continue to act for or on behalf of that shareholder, and any call option being exercised and any option completion subsequently occurring in accordance with the terms of this agreement. It then provides, if any valuation expert informs the shareholder after being so appointed that it is unable to continue to act for or on behalf of that shareholder shall appoint another valuation expert in accordance with the terms of this paragraph 3.2.
Yeah.
So that begs various questions. If the intention of the parties was that a third valuation expert should be appointed from the outset with default appointment by the ICC, just like the other valuation experts, why is that obligation not found in paragraph 3.2? Why instead is it to be found hidden away in a sub-paragraph of paragraph 3.10? If the party's intention were that the third valuation expert should be appointed from the outset, just like the other valuation experts, why is there no provision requiring the appointment of that expert to be maintained? Surely the purpose would be defeated if there were no such obligation. We know there's no such obligation to maintain the appointment because the provision has been made in respect of other valuation experts. The obvious inference is that the third valuation expert was not intended to be appointed from the outset. Likewise, if the party's intention that the third valuation expert was to be appointed from the outset, just like the other valuation experts, why is there no provision dealing with their resignation or retirement or ceasing to act, requiring a new appointment? And again, we know there's no such provision because it would have appeared in 3.2. The obvious answer is the parties never intended to appoint a third valuation expert from the outset. What JP Morgan's argument, I think, with respect, collapsed into was an appeal to commercial common sense, which was presented as being that the timetable is difficult because it will be tight. And the answer to that is the timetable is workable. JP Morgan accepts that it is workable in their skeleton argument for this appeal, paragraph 35.2, and asserts that it may be likely not to be met if there's a dispute. That's page 114 of the core bundle. Paragraph 35.2
mean, one thing that did occur to me thinking about it was that although the appointment would only be made conditionally upon 3.10 being triggered, I mean, there's nothing to stop somebody approaching the ICC ahead of time and saying, you know, alerting to the fact there is a clause which might require an appointment to be made within a certain period. So, as it were, you don't hit the ICC cold if the clause is triggered. I mean, is there anything wrong with that? Anything to stop that being done in the agreement? Is that unrealistic?
No, my lord, that's not unrealistic. And also, it is important to emphasise, in case it were not obvious, that the ICC is not making any determination here. They're simply picking a person from their list.
Yeah, so in other words, in a sense, the ICC, if the delay is potentially at the ICC, I don't understand at the moment why they can't be warmed up
Yes,
quickly if need be.
they could be warmed up, and in any event, it's a straightforward exercise. It's simply then picking a person. There's no submissions. This isn't the ICC sitting in its adjudicative capacity. It's simply identifying an expert.
Yeah, but
who,
you know, even within organisations, so you know, I mean, even if it's a simple picking an expert, if you walk through the door completely cold, you know, it'll take them longer than if they are pre at least
Yes.
notified there is such clause, and they might, within a certain fairly narrow time frame, be required to act upon it. Would they like to give some, they at least institutionally, make any arrangements in advance
Yeah.
such that if they're told they need to do it, can they do it without delay? I mean, is any of that, I mean, there's no reason why we should assume that's
No.
beyond the ken of the ICC.
No, and the parties will know in any event in advance because they'll have the valuation experts who are 15% apart. But in any event, the ICC could be told, we have these measurement dates coming up every 6 months. You could be required to appoint an expert to deal with these
If they
particular
can't solve
windows.
it within the next 10 days.
Yes. Yes. And a point was made, I think, forensically by my learned friend to the effect of, we'll look at the length of time that was encountered with the debate with the ICC previously in this case. Well, it was a completely different situation because if JP Morgan sought to appoint a valuation expert in circumstances where the ICC didn't have jurisdiction to do so. Didn't have jurisdiction to do so because if the ICC was being invited to appoint an expert in circumstances where there were two defective valuations. Because the valuations were 15% apart, but they were vitiated by manifest error because they'd been prepared on the incorrect basis. They'd been prepared on the basis that Regulation K applied. WRL objected to that, and WRL was right to do so, as the judge held. The judge held that the ICC did not have the jurisdiction to appoint the third valuation expert because the conditions were not met. But that doesn't tell one anything about how long it will take the ICC to appoint an expert from their list in circumstances where the valuations are 15% apart.
It is, as Mr. Hadisai says, a very tight timetable.
Yeah.
And I wonder if we could just run through it briefly so that I've got it. We've got a measurement date, and the parties' experts are supposed to produce their own valuations within 15 days of the measurement date. That's right, isn't it?
Yes.
And at the same time, that is to say 15 days after the measurement date, the window for exercising the option opens.
Yes.
The window remains open for 30 days.
Yes.
So if the third expert is going to do anything in time for the expiry of the window, closing of the window, they've got to be appointed within 15 days. 15 days plus 15 equals
Yes.
30. And so the JPM may be at risk of waiting almost until the end of the option period before deciding whether or not to serve the notice. if they don't, then the WRL option is exercisable on the following day, isn't it? Because the first WRL option exercise date is 31 days after the JPM first option date. Is that not right? I was a bit puzzled by this idea that WRL has to wait 6 months.
The 6 months arises in circumstances where JP Morgan exercises and WRL rejects.
Oh, I see.
Okay.
So yes, we agree it's a tight timetable, but these are unambiguous clauses. It's the timetable the parties agreed upon. It must have been obvious to the draftspeople that what they were creating was a tight timetable, and they went ahead and did it anyway. And we say there's no reason, therefore, to rewrite their bargain. If they've created something which is imprudent or impractical, then they have to live with that. But my Lord Justice Snowden has identified a means of mitigating the rigour of the timing provisions.
But what they will know is what the party's own experts say the value of Viva is.
Yes.
So they'll know if there is a dispute, they'll know the parameters of that dispute.
Yes, and the data will all be ready, and the experts only have 15 days in any event and in any circumstance. The party valuation experts only have 15 days to prepare their valuations. Now, that may in turn require those valuation experts to do some preparatory work in advance, to line up the people, to familiarise themselves with the business, say. But again, those are extra contractual matters which, rather, if I might adopt my Lord Justice Snowden's observation, there's nothing stopping them doing that under the contract if they wish to do so.
You say tight and possible is no reason to depart from the express wording.
Yes.
If it was impossible, then we'd been in a different world, something might well have gone wrong, and you'd have to start looking at whether you, by some form of corrective interpretation, could produce a procedure which actually did work, given that the parties plainly intended to have one.
Yes.
But you just say we're not in that world.
No, and JP Morgan
we're in a tight timetable, but it's workable.
JP Morgan have not suggested otherwise in paragraph 35.2. So exactly. So we say it's a problem that the parties have created for themselves, but the court, there's no reason for the court to intervene to change it. Second issue that raised by JP Morgan concerning the valuation expert is ground 4. This concerns whether under paragraph 3.10 it is a condition precedent to the appointment of that expert that the determination of both valuation experts are not subject to manifest error. The learned judge was, with respect, quite correct to hold that it is a condition precedent. It follows from the express terms of paragraph 3 of Schedule 1. It's also, we say, a matter of common sense. If I might look at paragraph 3.10, page 530. So,
Sorry, can you just explain the proposition you're advancing here again? I just wasn't sure I quite heard it right.
it's a condition precedent to the appointment of a third valuation expert that the determinations of the valuation experts are not subject to manifest error.
Well, 311 is predicated on, assuming you go through the third valuation expert exercise, you get to a figure from the third valuation expert, and you then take the average of that value and the value of the other nearest expert. That's why it's like a baseball arbitration.
Yes.
But that's all predicated upon these being valid values, effectively.
Yes. We entirely agree.
If they're not valid values because there's a manifest error, then the whole thing is unworkable, isn't it?
We respectfully agree, my lord, and that was going to be my common sense point, which is, what is the purpose of appointing a third valuation expert to go all the way through to the end of the process using defective, in the circumstances where there is a defective valuation or defective valuations, because the output is going to be useless, because the output is going to be a figure which has been vitiated by manifest error as well.
I mean, I thought you get this, I mean, maybe I've got this wrong, but the closing words of 3.5,
Yes.
when it says, save in the case of fraud or manifest error, the decision is final and binding on the shareholder, the valuation experts. Decision is final and binding on the shareholders and the parties who must proceed with the valuation experts' decisions. I mean, what does who must proceed with the valuation experts' decision encompass? It presumably does, as I would understand at the moment, it must encompass proceeding with the appointment of a third expert if they are more than 15% apart.
Indeed.
So in a sense, you start at 3.5, don't you?
It must include the procedure under 3.10. If they are more than 15% apart.
Yeah, but if by way of manifest, if it's manifest on the face of one of the valuations that there's been an error, with the consequence that if corrected they would not be 15% apart, you're not obliged to proceed on the basis that they are. You just correct the something which is by definition manifest error.
Indeed, and that's one way of, exactly, we entirely agree, that's one way of, the way the judge looked at it, of concluding that one doesn't proceed with valuations which are vitiated by manifest error, because parties aren't obliged to do so, as per paragraph 3.5, which reflects what one would expect, which is that if they are manifestly wrong, then the parties shouldn't have to proceed on the basis of that manifestly wrong basis. The other route of getting there is because of what the valuation experts are doing under 3.10b is determining what is the call option fair market value. See that from the chapeau to paragraph 3.10. Call option fair market value is defined in paragraph 1 as being the fair market value of shares as determined in accordance with paragraph 3 of this Schedule 1. Same point is made in paragraph 3.1, which is that the call option fair market value of the shares is to be valued for the purposes of this schedule, shall be determined by an expert in accordance with this paragraph 3. Accordingly, if there has been a manifest error, there hasn't been a determination of call option fair market value at all. It won't have been determined in accordance with paragraph 3 because it's been vitiated by manifest error. And so therefore, again, there's no condition precedent met going ahead to the appointment.
I think as my Lord Justice Lewison said yesterday, I mean the scope of manifest error is quite limited in a way. It has to be manifest. It has to be obvious without any further, other than the most rudimentary examination, that there's an error.
Yes.
So it's not really there to cope with disagreements as to the basis of valuation, which is possible where experts could agree. It's there for experts having valued the wrong shares or at the wrong date or given a range rather than a single figure, I think was the example I picked.
Yes, I mean in this case to deal with the forensic point that my learned friend made on at least a couple of occasions yesterday, saying that my side objected on the ground of manifest error before seeing the report. True that is, but that followed correspondence, which to be fair my learned friend did mention, that followed correspondence in which we said, well, the experts are proceeding on the basis of defective projections and a defective approach to valuation because they're proceeding on the basis that Regulation K applies. Freshfields, on behalf of JP Morgan, accepted that's the basis upon which their expert was proceeding, and as was indeed WRL's expert, and the consequence is that both valuations are vitiated by manifest error. That's why one doesn't need to see the report.
Well, I must say, I find that difficult. There is an argument which you've had for several days in the High Court, and now again in this court, about what is the correct basis of valuation. And one of you is right and the other one's wrong. But how is that a manifest error? Manifest. Maybe an error. How is it manifest?
Well, my lord, I mean, it perhaps doesn't need to detain us now, because I think it is only a forensic point, but we say that it is manifest because it is clear on its face. It is clearly if we are right in relation to the basis evaluation.
It didn't need all of you to come and then argue the point, did it? You could have actually done it with a baby junior.
Well, my lord, we wouldn't accept that the manifest error has to be the yardstick for manifest error.
So with no disrespect to juniors, but
No, my lord.
But a manifest error is, it's a concept that, as the Lord says, has a very narrow scope. Very narrow scope. And there's plenty of authority on what's a manifest error in this sort of context. And something that's alleged to be an error over which the parties have argued the toss for 5 days does not, on the face of it, seem to me to be a manifest error.
We say that the yardstick for manifest error is not how long it takes to determine or the submissions that might be made in respect of it. We say the question is whether or not it's visible on its face. Here it is visible on its face without any further determination, because it's a question of what is the basis of the valuation. We say that valuation basis was wrong.
Anyway.
How is that on the face? There's another thing I don't really understand. It's not on the face. It's in the underlying correspondence.
Well, it's
If you look, for instance, at the valuation certificate, supplemental bundle, tab 8.
yes.
This is the one from Young. It just says, this is we concluded in our valuation report that as of the date is fair market value is 3 billion. Full stop. That's all it says. Now, how can you get a manifest error out of that?
Because we know the basis upon which it's been prepared. If that was blank, my lord, and that not been provided to us, then that wouldn't be the case. But we know the basis upon which the valuation has been prepared. We also relied upon the fact that it's a small percentage of the previous figures that were used, and there's correspondence in relation to that as showing that it was a manifest error. But again, it's really ultimately just a forensic point. The proposition here we're dealing with is whether or not it is a condition precedent that there should not have been a manifest error, and we'd say that is a condition precedent, and that's what the judge below held, and that emerges quite clearly, we say, from either the two routes, either determination of call option fair market value, or by reference to paragraph 3.5, as my Lord Justice Snowden observed. My Lord, ground 5 concerned alleged breach by WRL in not appointing the third valuation expert. That ground is entirely contingent upon ground 3 or ground 4. We say that as we are in our submission correct on 3 and 4, the appeal on ground 5 also fails. The final third valuation expert ground, because ground 7 is contingent upon ground 6, is ground 6, and ground 6 concerns JP Morgan's argument that there should be an implied term that the first option exercise period should be extended for quote unquote a reasonable period. And we say the learned judge was, with respect, quite right to conclude that in this detailed and sophisticated commercial contract containing a precise timetable for the valuation process, and the parties exercised their respective rights to exercise call options according to that timetable, there was neither room nor necessity for a term to be implied, let alone a vague and open-ended one that would wreck the timetable. We say that there are 2 reasons why the term should not be implied. First, the term is either contrary to clause 39.1, which requires cooperation so as to ensure that provisions under the agreement are completely and punctually fulfilled, or clause 39.1 makes the implied term unnecessary anyway, And this is a point the learned judge made in paragraph 287 of her judgment, which is at page 243.
Yeah.
Second reason, we say, is that the implied term in any event is certainly not obvious. It is far from obvious that where the parties have established a detailed framework and timetable for the exercise of call options, that their preferred contractual solution would be to replace that timetable wholesale with an open-ended extension of time. And this is also a point that the learned judge made in paragraph 287 of her judgment.
Yeah.
How, for example, is this extension supposed to correlate with the second and third option exercise periods? Is it suggested that they run alongside each other? Is it suggested that this extension of time might go beyond the second period? Is it being suggested that the second period might lapse on the third period, but JP Morgan or WRL still be entitled to exercise rights from the first period?
Yeah.
Is it obvious that that's what the time of entering, because we're looking, of course, at the time of entering into the shareholders' agreement, is it obvious that that's what the parties would have wanted, rather than wanting punctual performance of their existing timetable, as clause 39 would entitle them to expect?
Can I suggest a slightly different approach? If we look at 3.10, which is where this comes about, this is where it springs from. If the valuations are more than 15% apart, then the parties shall appoint any one of the firms as the shareholders may agree. So that's on the face of it, an agreement to agree. And if agreement is not reached within 10 days, then either shareholder can go to the ICC.
Yes.
So on that basis, the implied term just isn't necessary. Because if there's no agreement, then either party can go to the ICC and say, please appoint a third expert.
Yes. Yes. They can do so, and we entirely agree, my lord. There's no
You don't need to
necessity.
get into clause 39(1) or anything, you just look at clause 310. There's an agreement to agree, and if there isn't an agreement, you go to the ICC.
Well, I think, well, my lord, we entirely adopt and endorse that observation. I think that JP Morgan's case is put on the basis that one can't trust the ICC to be able to do their appointment.
Well, maybe the parties have picked the wrong appointing body, but that's who they picked.
Well, that's what we would say. We would say that one assumes that the parties comply with their obligations and their rights under the contract, and that one can't proceed on the basis of interpreting the contract that the parties may breach or will breach their obligations, or that a third party such as the ICC won't do its job. So we say, we respectfully adopt that, we say it's not necessary, even if it might have been said to be something which didn't conflict with clause 39, the parties have come up with their own solution, which is either clause 39 or my lord's observation that they have a regime and a mechanism under paragraph 3.10. And it's certainly not obvious in any event. And what the King Crude case says, and the learned judge referred to it, the judgment of Mrs. Justice Dias in King Crude Carriers, that's paragraph, is paragraph 286 of the judgment, is that when one implies a term to deal with the case which JP Morgan advancing, they say a party should not be entitled to take advantage of their own wrong. What Mrs. Justice Dias says, and with respect is entirely correct, is that the ordinary rules apply. One still has to have a basis for implying a term. And we say it's not necessary, it's not obvious, and therefore no term should be implied anyway. My lord, the only final ground therefore is number 7, and that ground is contingent upon there being an implied term. We say because there's no implied term, the consider must fail to.
Yeah. Okay.
My lord, may I turn my back? My lord, those are my submissions on those two areas of the appeal.
Undecided. I'm sorry. I have to be at something in the main building
Yes,
at 1 o'clock.
yes.
So I really need to rise about not long after 1:45, to be absolutely honest. So
Right.
do you want to start now, or do you want to?
Can I just give you, in 5 minutes, I can give you the main
Yeah,
point
that's
on
absolutely fine. I
ground
just
one.
didn't want you to sort of head off on
No.
your submissions and then find. I'm pretty certain that I can be back by 1:50, so we can start again at 1:50.
Well, I'll see if I can get my main submission on ground one out of the way, and I'll come back and do the authorities
Yeah.
whenever we come back. But firstly, just to say, you were taken yesterday by Mr. Weeks to some evidence, Mr. East witness statement, paras 17, 22 and 37. If there's anything, if there was anything in those paragraphs that your lordship think is relevant to the issues before you, can I just tell you where JP Morgan's evidence in response is, so that you have that? You need to look at Mr. Robinson's first witness statement at paragraphs 22 to 24. That's core bundle 8B5, page 438.
Sorry, core bundle where?
Core bundle tab 8B, page 438, paragraphs 22 to 24, and page 441, paragraphs 28B and C.
Sorry, you're putting up with some
Sorry.
fairly heavy competition behind me.
I'm sorry, my lord, I will do better.
8B.
So it's Mr. Robinson's first witness statement. I'll give you the paragraph numbers first. Paragraphs 22, 24, and 28B and C. And the reference is core bundle tab 8B5, page 438 and 441. I'm not going to go there. I'll just give you this, unless there was something that particularly caught your interest that you wanted me to come back on. Now, on ground one, cutting to the chase, JPM accepts the valuation is to be conducted on the basis of an open market sale of a going concern between a willing buyer and a willing seller at arm's length. That's what clause 3.7a says. The point of dispute, as I said yesterday, is the basis on which the financial projections contemplated by paragraph 3.6a and required to be provided to the valuers under paragraph 3.7b6 are to be prepared. Paragraph 3.6 gives some high-level guidance to the methodology that the valuers can deploy. 3.6a contemplates assessing the historical and projected financial performance of the group. And that, we say, requires an assessment of the actual performance of the group and its projected financial performance based on its proposed actual business across the relevant periods. But 3.6 does not say that any valuation of the group must stop there. Subparagraphs B and C of paragraph 3.6 mandate the valuers to apply a range of generally accepted methodologies for valuing the group. And so, if the valuer, having regard to the other valuation methodologies and comparisons with publicly disclosed sales of other companies and all the other things that are referred to, if the valuer, having regard to those methodologies, considers that a prospective purchaser or purchasers would attach a premium to the group, for example, over and above any value that might be implied from an assessment of the actual performance of the company, historical and projected, to reflect its untapped potential in the United States, then it is open to the valuers in the exercise of their professional judgment to adjust their valuation for that. That's the key submission. I'll stop now, but I see you're anxious to.
No, I'm not.
Well, I don't want to make you late for your meeting. Happy to stop there, and we'll pick it up at whatever time is convenient to your lordship.
You tend to do. Do you think that's all right? Isn't it? Do you think?
Whatever suits you.
So I can always slip away later. Yeah, okay. 10 to 2. Yes, 10 to 2 then, please. Thank you.
Court rights
We're all right. We're making good progress, aren't we, generally?
Yes, I'm going to be short in reply, and then
Thought you were.
I think we might be a bit behind, but that's not. Yeah.
We can always make it. Yeah, thank you.
Court rights are favourable.